Super. Welcome to our second webinar on artificial intelligence, on AI. Thank you very much for attending. Thank you very much for your interest. We have a record number of people who registered for this session. I think it shows that this is an intriguing topic, a topic that raises eyebrows, raises a lot of questions, questions also in the legal domain. My name is Niklas Schmidt. I'm a partner here in Vienna at Theiss. You might remember that I did the first of these three sessions, the session 3 weeks ago, where I went through all of these AI tools that you should be using, tools that your kids might already be using. And today we're going to focus on legal questions. So what has happened since the first installment of this webinar series? What has happened in the last 3 weeks? The pace of speed in the AI area is really incredible. So many tools have been upgraded. So you might have read, for example, that Midjourney released a new version. So when I was speaking 3 weeks ago, we were speaking about Midjourney version 4. Now we're already at Midjourney version 5, which generates photos totally realistic. The first deepfake issues have already come up, and actually Midjourney has just today announced that they are not going to release the version 5 to the non-paying public. OpenAI's large language model has also been updated. You might have read this tidbit, this bit of information regarding this US bar exam. It's called the MBE, the multi-state bar exam. The previous version of OpenAI's tool had a 50% pass rate. The newest version, version 4.0, has a 75% pass rate. So things are really moving along. There's also been a study by 4 researchers, 3 of whom are affiliated with OpenAI, and they basically said that most jobs will, to a certain extent, be impacted by AI tools. There are only, I think, 37 professions where there's zero impact of AI on these professions. These 37 professions include such sexy occupations as stonemasons, motorcycle mechanics, and cafeteria attendants. There was just yesterday, I got another study, this time by Goldman Sachs, where they basically said the profession of lawyers, so our own profession, is on the top of the list, is number 2 of the professions being impacted by AI. So things are really moving ahead. Nonetheless, the last topic I want to mention is Elon Musk's proposal a few days ago to halt AI development until we see where things are going to go. So to make a stop in this area for the next 6 months. And the UNESCO has just released a kind of report or something where they're saying we should really look at the ethical implications of AI. So a really fast moving area, and lots of things happening. As I said, today, we're going to look at some legal aspects of AI. And I'm very happy to be joined here by 4 experts from our firm who are going to lead through these 4 topics. The first topic will be devoted to copyright issues of artwork that has been generated by AI. So think, for example, of Dall-E 2 or Midjourney or many of these other Leonardo, many of these other applications out there. Then we will be having a presentation on the liability of an AI system for copyright infringement. So can an AI tool actually infringe the copyright of people who have created artwork and whose artwork is now being used? Then the third topic will be a liability topic. So liability for harm done by AI systems to human beings and also to assets. And last but not least, we will be having a very interesting presentation on the usage of AI systems in human resources and whether there are any restrictions on using AI. So let's move on to the first presentation, copyright of AI-generated artwork. And let me introduce Paulina Pomorski to you. Paulina is a counsel here in Vienna, here at the Vienna office of Theiss. Paulina is a member of the IP and TMT team. She focuses on data protection, on IT law, on intellectual property, and unfair competition. And with that, I would very much like to hand over to you, Paulina.
Thank you very much, Nicholas, for this wonderful introduction, and very well welcome also from my side. So yes, let's have a human webinar here from lawyers, as long as we're still relevant, as we just heard. That might not be true for our future, but yes, when we think about AI-generated content, especially artwork, we of course think about questions around copyright protection, or well, maybe at least I do as an IP lawyer. But well, I don't know how about you, but I really get excited when I think about AI and copyright law, and simply because it's like a relatively new field, and there are all these very exciting questions to explore. And so today I do hope to, I will try to answer at least some of the basic ones, and this all in the speed of light of 20 minutes. So yeah, I believe the first slide already is quite provocative, where you see a robot painting an artwork, a painting. So yeah, this just brings us in the midst of the first question, whether an artwork created by the machine can be protected by copyright law. So in order to answer that, maybe first at the outset, without a super complex technical definition of what an AI is, let's agree that AI and an AI program is not a human being and is implemented by a human being, a very complex system, processing data and making conclusions based thereon. So what we need, however, in copyright protection, copyright law, for a certain work to be protected, is defined, of course, in Europe within a different Copyright Protections Act. And in general, we can say that the content or the creations qualifying as works need to have some peculiar intellectual creations, peculiar intellectual creations. And in Austria, particularly, it is defined as being in the fields of literature, sound art, fine arts, or cinematography. But so if we look closer at this, and you know, again, this is like a definition under Austrian law, but they're more or less similar also in other countries or member states of the EU, I may say. So peculiar and intellectual means, at least according to Austrian case law, that it has an individual character derived from the personality of the creator, so of the author, and that this stands out from the everyday and completely trivial. So this does not mean that it needs to have a very high value of special artistic, scientific, or aesthetic value in order to qualify as work. So it can, let's say, also be unaesthetic, and it could be simply a normal picture taken by a person. And the next point, which is relevant in this context, is the creation itself. So what can be a creation? The creation is simply a creative result, which, however, is noticeable externally, so outside of our imagination, of our head, and which other can also notice. So you may also say that it is the idea that has taken shape. And this is very important to remember, as it means that ideas as such are not creations and therefore cannot be considered works. Okay, so we have now the super basic components of requirements for creation or content to be considered as art, as works. And where does it leads us when we consider that and ask ourselves, can a program be actually intellectual, and therefore can be an author under copyright law? So yeah, the answer is a straightforward no, because a program, a machine cannot be intellectual. At least this is considered for the time being. So only human beings can be considered as an author under copyright law. And consequently, this means that simply a work produced, generated by an AI program would not be protected as a work under copyright law. But there might be other possibilities, which we will get to right now. So next thing would be, so what you would say, what about the prompts? Yeah, so the prompts, this is the input what a person writes, let's say the instructions into the program online, and based on that, then Dall-E or Midjourney then creates actually the content, the painting, let's say. And so if you remember just what we discussed before, a creation or a work needs to be perceivable externally, which means that mere thoughts and ideas as such are not protectable. The same is true, for example, for artistic styles. So only once, if we think about artistic styles like a style of a painter like Hundertwasser, an Austrian artist, these would not be protected as such. Only once such a style is applied and turned actually into a work, so a result, a creation, like let's say a building or a poem, then this might be protected and may be protected under copyright law. And therefore, the same principle also applies to prompts, as there are the mere ideas of the user, who writes the instructions, and as such they are not protected, because the creative process is also not then performed by the user, but the program as such. And yeah, there argues, you can argue that you don't simply know how the result in the end will look like, because when you type in the prompts, these are just abstract ideas, and again the program then creates or does the creative process, and you don't know what, based on your prompts, how the image will look like in the end. But there are also arguments, and this is exactly still, of course, this exciting and gray area, where you say that you could argue that also artists, for example, when they are painting, and I know this from a very close personal experience, that they also don't know how the end result of the work will look like. If you think, for example, about Jason Pollock or Nietzsche and their so-called drip paintings, where simply paint or blood was spilled on a canvas, nobody can say that they knew how the end result will look like. So the paint or the blood or the brush was merely the tool, and of course the end result, the painting, was still protected, or is still protected under copyright law. And so there are arguments where you to say that this could be also applied to AI programs. And so we come exactly now in the area where we speak about possible workarounds. Another possibility would say, if we stay here still with in the area of prompts, that you say that, or it is argued, at least now for now in literature, that where the user who provides the input, the instructions, provides such a precise and detailed instructions prompts, and the AI, on the other hand, has so little leeway to decide and be actually creative. So, but you can really argue that the creative process lies with the users, and there maybe potentially there would be the possibility to say that the users were actually the creators, but this is highly debated. So we said already that neither the AI nor the users in general who provide the input would be in general seen as the author under copyright law. So maybe the engineers who created the AI program, this would be a reasonable argument. However, in generally also at the moment, it is argued that they are not the authors because they are not involved in the creative process than in the individual case. So they only at the beginning program the AI in general, and therefore they are then not involved in the creative process anymore. But also here at the moment there are arguments against this, because in under copyright law you have also protections under the so-called related law rights, and there the idea is that you can also protect the results or like here the program in a way as to compensate for the investment when creating the idea. So there's, for example, the protection for databases, and there exactly the idea is to compensate for the investment to create this database. Therefore, the database is also protected. So maybe that would be an idea, of course, which would most likely have to be put first into law, or otherwise, yeah, maybe developed in case law, but that would be rather difficult. Then another possibility would be simply, if you think about at least the concept of assumption of authorship under Austrian law, it is like that if a person is named as an author of a certain creation, of a certain work, then the authorship will be presumed under Austrian law until proven otherwise. So this means I can create simply a painting through Midjourney, for example, and then just publish it and say I was the creator, it's my doing, I'm the author, and then it would be the burden of proof with the person contesting my authorship to show that I was not the author but Midjourney. And yeah, so that would be then the difficulty to show. And last but not least, a thought which is also often raised at the moment is that if you have the AI generated output, the work, what if it is then further processed and further adapted by a human being? And so if to this output a further creative work is added by a human being, then of course it can be argued that the further developed content would be then in the end protected by copyright law. So yes, we of course also asked ChatGPT what it would think about the question who should be the owner of copyright, the copyright owner of AI generated work. And guess what? It was not answered very clearly by ChatGPT, and you may read it then by yourself. It's quite interesting, and I believe as an answer. And so in the end, this means that it remains with us to decide on this question, and I believe there will be a continuous and interesting discussion on this. Thank you.
Super. Thank you very much, Paulina. I think this is a super interesting topic, and there are so many questions which immediately come to mind. I did not tell the audience actually that if you have a question, please put it into the chat. and we will collect all the questions. And once we have done all 4 presentations, we will address all of them, and so that you get answers, hopefully. Let's move on. The next presentation is by Peter Ihasz. Peter is a senior associate in our Budapest office. He is with the corporate and M&A team, does a lot of work in the areas of mergers and acquisitions, of restructurings, and all of this while focusing on transactions that are tech-oriented. So technologically driven transactions is something that Peter is enthusiastic about. Peter also deals a lot with IP, data protection, and consumer protection issues. And as you can see from Peter's slides, he's also an avid user of many of the tools that he will be actually speaking of as a lawyer. His presentation is on sort of the input side of these AI systems, the images that these systems have seen. For example, I think Dall-E 2 has seen like 650 million images, images which have been tagged, and images which form the worldview basically of Dall-E 2, and which then sort of lead to the results that the user gets when he types in a prompt. So Peter, over to you.
Many thanks, Nicholas, for the very kind introduction, and welcome to all our guests and listeners. Yes, the whole question of AI-driven content creation, I think, is a fascinating and rapidly evolving part of this technological arms race, basically, that's now developing, or we've been seeing in the past couple of months, really, but leading up to this point in time. And as Nicholas also mentioned, the call for a cooling period from those tech gurus, basically, in this area, Elon Musk, and also Yuval Harari, basically one of the historians and critics of today's civilization, has also raised voices against it, and just goes to show how dominant a question this is. And how dominant it will become, I think, in the tech sector, and also has its own very distinct legal issues that brings it with itself. As Paulina already mentioned, the copywriting, claiming copyright protection for works created by these content creation platforms, these generative AI solutions, is already in itself a hard nut to crack. But as we delve really deeper into this whole topic, I think also the possible infringement cases are also something to really keep in mind, and to also from an ethical perspective, as well as from a legal liability perspective. And so just a couple of words, what are generative AIs? These are artificial intelligence systems that can create various works, which can be range from literary, scientific, artistic. Basically, we have general, more general solutions like ChatGPT or its contenders, as well as those that create pictures or even video, for example. And how do they work? We'll go into more detail, but on a very general scale, I think we can just say that these are very well trained algorithms, trained on terabytes or gigabytes of hundreds of gigabytes of data, and these algorithms recognize patterns, they make predictions, and thereby with very complex mathematical solutions, they create new content, ranging again from all kinds of work that may be subject to copyright protection, and that may potentially also infringe. And that is the great question here, really. And what we will be looking at, and what really poses dangers here, is how they are trained, what data sets are used during their training periods, what concepts of copyright law we see here in terms of the data set being applied to the data sets used. And also we have to mention the biggest issue here really is that this black box effect is that we don't quite see into the mind, quote, of the AI. Hence those algorithms that actually create these contents are somewhat obscure to us. And during my slides, you will be seeing, well, funny or just nice looking, but equally impressive works of art created by Dall-E. You will be seeing the prompts that I've supplied the AI with. So just very quickly, what type of AI these generative AI solutions are? We have reactive machines. Those are just basically your Instagram filters that provide you with some other hair styles if you allow it to scan your face. But moving on to these more complex ones, these are limited memory AIs, and the most prominent one that are now used are generative adversarial networks. So-called GANs, which rely on training. You input them, they give you a prediction, then you provide them with the feedback if these are fine or not, and then the training cycle continues, all while being trained on again huge data sets from which they can use and store the required information for the algorithms to work. We've got some other AI types as well, but those currently are still not here. And there will be no self-aware robots roaming around in our offices soon. Some eye-opening, maybe nice infos for you. Again, ask ChatGPT what the issues of risks of using generative AI solutions may be, giving us some very nice, albeit general replies. But if you just look at the right side of the slide, you will see a infographic or a picture very nicely showing how these generative AIs are trained and how they basically work. So they receive there's a database which they use and they've been trained on, and once they release to the public, users have a possibility to input prompts, and using those prompts, which can vary from some very general ones, as you see in the pictures in the previous slide, can go to you can even input poems or more specific literary works even that may have their own copyright protection, for example, may be eligible for those, which will be then used to generate content with the algorithms these AIs use. Just a couple of examples that Niklas already mentioned. There's OpenAI's ChatGPT and Dall-E. There's Midjourney with the creating Pope Francis's very stylish photorealistic pictures in this super stylish coat. There's also Stability AI with its Stable Diffusion, DeviantArt, and Google with its own AI assistant and new picture augmenting service. What are the infringement cases that we are basically trying to wrap our head around? And at this stage, really, it's all about guesswork and all about trying to apply the currently applicable laws, which are in many sense general enough in order to be used with the use of allegories, but at the same time still ongoing mostly in front of US courts. And the one of the biggest questions is that due to the mechanics of the AI, the whole copyright infringement issue can occur at various stages. It can occur at the point in time where the input is provided to the AI itself when it is trained. It's a huge question what types of data sets the AI's training is actually conducted on, and we'll see in later slides some case law that's actually reflect on these and are already ongoing. And the question itself that if the user who is prompting the AI, what type of prompts it provides, how direct it is, how much it is trying to copy basically and recreate a previous copyright protected work. And then we have also the content that is generated, which is again a question itself, because given that there's some obscurity in terms of what the algorithm does and how it works in full, we have some issues in kind of identifying if the actual output it works, the output itself may or may not infringe. And then the question of whether our legislation is now up to the task to actually tackle these issues. The EU is now being very active, and lawmakers just in the recent days have announced that they will be looking at AI liability for these generative AI solutions, which is definitely something that is on the table. And as mentioned, US courts have already some cases on the table, looking at various issues that we will discuss later. So some topics that definitely we want to touch upon, or is worth touching upon, and at this stage again, it's more about asking the right questions and then trying to apply what we know so far, and then see how it all unravels. As mentioned, the data sets for training is a crucial element to look out for, and definitely a risk factor when we are talking about creating an AI solution, for example. So for any software development oriented companies that is trying to create its own AI generative AI solution has to take care, or has to definitely be considerate of the data sets and any licensing issues that may arise from using works that are subject to copyright, and also being and also being careful that the fair use doctrine that consists of different or slightly different concepts in the US and in the EU. What's that thin line that can be used for using certain copyright protected data sets, and how that can be brought together with creating these solutions. A question, as Paulina mentioned, any claims that may be there for copyright of those works that are created by these solutions. How is the created work impacting other copyrighted work? Is that a infringing content? Can the AI itself, or the user of the AI, or the software development of the AI held liable? Is it unique enough? Does it contain those individual original elements, the created work, that may allow it to be eligible for copyright, or is it a transformative work? And these are hard questions to answer, because we are not quite, we cannot quite grasp the processes that are ongoing. And of course, the terms of use of these platforms that provide these services, which may provide for all kinds of indemnities and liability provisions between the parties and those using it. Also, what applicable laws there are in terms of these solutions, and how these will affect these potential cases that may be prompted by these works. Some cases that I wanted to mention in terms of the input-oriented part of these solutions. One is the already ongoing class action lawsuit against Microsoft and OpenAI, they've created a solution called Copilot, which can produce code, and already the issue is that the snippets of those authors that have created these software solutions and codes have a legal issue, which they brought in front of court, that their copyrighted works are actually used, or were used to train these solutions. Very similar issue with the image generation or AIs that generate images. Basically, that the pictures used for training them have been scraped from the internet. And again, all kinds of legal defenses around fair use have their pro and con arguments, of course, on both sides, but definitely the technology itself apparently is using data from the internet, which use of data may or may not be noted to or notified to those users or those creators that have been affected, and their pictures or creations have been used to train these AIs. And then there's also currently discussions ongoing and commercial discussions ongoing to settle or try to settle or even proactively try to calm down the nerves of content creators on the internet by setting up, for example, a general fund to provide compensation to those creators whose work has been used for data for training these AIs. So it's definitely something that I think that is acknowledged by those players on the market that are operating these solutions. However, the obscurity and the yet undecided court cases definitely will have an impact on how legislation and how lawmakers and courts will be looking at the whole setup and the whole content creation process of AI. And some interesting parts on the interesting cases on the output side as well. A successful copyright claim for Zarya of the Dawn, where the novel created itself and the pictures there too received copyright. The novel itself received copyright protection. The picture is not. However, there was a backtrack of the court ruling actually in the US. So it's still redebated at the moment. And again, it's a huge red flag on how accepting are courts at the moment with a more rigid mindset of these AI created works, which also again brings about the question of what we consider the AI itself. Is it a tool, a mere tool that is prompted in a way that allows the prompting user, i.e. the creator, to create something with its own unique prompt, and there's no other, and it's really just a paintbrush. Or it's really the transformative algorithmic workings of the AI generation, of the generative tool itself is carrying any own or adds some uniqueness to the product itself that again raises copyright claim questions. And it also just a very interesting one, the David Guetta creating a track in which it is managed to successfully generate an AI-generated voice of Eminem, which he did not release to commercial use, of course, but again shows everyone the ethical and copyright infringing potential of these outputs. And all the questions that I've listed below are basically are out on the table, and will only allow us full understanding if there is if we have a better or a very clear understanding of the technology itself, which is in many cases, as we see in the US court cases, are still somewhat incomplete. And how to manage these risks is also a super interesting question, because definitely there is there are potential ways to try and mark those data sets that are used for input. For example, that was one of the issues of one of the court cases also now discussed with Get Images, is that there's the outputted image actually actually also showed the watermark, which is I think was an eyebrow raising outcome for everyone. But again, it shows that watermarking and marking data sets and pictures may be a useful tool. But it's equally a useful tool to just use data sets that are from the public domain and nobody holds copyright over them, or actually just obtaining those copyright permissions that are required. And then how we can actually see if how we can backtrack. Again, technology is also being developed that can actually see and understand and try and label generative AI created output. In terms of conditions, again, just touching on this briefly, it's I think it's one of the most important things to consider, as much as we are looking at underlying legal concepts. It's also equally important for everyone now to take the time, and I think to learn about these terms and conditions and to understand the role of these in how these may impact the created works and how these interact with the whole use process basically of these generative AI platforms, because it can point us to governing laws that fall outside our understanding, or get us to parts of the world that we are not very much versed in. We may forfeit, or we may be granted license and also be conferred liability that we may or may not want to do so, or we may or may not want to accept when just generating all kinds of images with these platforms. And of course, we may not rely on ChatGPT or OpenAI saying that they will of course take the blame for any copyright infringing use of the works created, as their liability and the liability for their service is very, very strictly limited. And just a couple of final thoughts to wrap up really is one of the main messages that I wish to convey to everyone is the rapid advancement of this technology, and we are really not allowed to peek into the future. Just seeing the past 6 months is mind-boggling really. And the plethora of legal issues this brings with itself, I think, is definitely a major challenge. And users will have to be very considerate of what they create, what they use, and in which environment they do that. We have to understand before using. I think this applies more than ever, that before we start using any of these solutions in a commercial setting that may bring with itself copyright infringement issues, we must understand how the whole program works, how the actual platform works, what terms apply, and understand how we may become liable. And we'll have to see how court cases currently going will just run their course, what they will conclude on. They will definitely shape the world and shape the regulatory landscape in which these platforms will operate, and we will have to wait for those to really run their course. And we will also have to be careful where and how we apply these platforms, as again, copyright law somewhat differs in several parts of the world, and we may not just, there's no one-size-fits-all solution really. And just a concluding sentence is that I think as we see deepfakes, as we see ethical issues, we should strive for a fair, ethical, commercially viable, and legally acceptable use of these new but really very powerful technology, hopefully shaping our lives for the better. Thank you.
Super. Thank you very much, Peter. That was a great run through to these issues, and we're going to move on to Jakub Pietrasik. We'll be speaking about liability topics, in particular coming from the European Union. Let me briefly introduce Jakub to you. Jakub is counsel in Theiss Warsaw office. He leads the IP and TMT practice there, has 13 years of work experience, and does a lot in the areas of IP and technology transfer agreements, license agreements, IT development, IT outsourcing, R&D projects. He has a very strong interest in AI, in crypto assets, in robotics, and in all future-oriented topics. So with this, I'm very excited to hand over to you, Jakub. The floor is yours.
Thank you, Nicholas, for the introduction. Hello, everyone. I have a pleasure to speak about the liability for AI-assisted products. I'm going to use the example of autonomous cars, and all this in the light of recent EU proposed legislation. I think this is a very interesting topic, and what's the general idea of creating a regulatory framework for AI. So firstly, the first idea is to establish safety measures for all the users, for all final users, so consumers and all of us, when using the AI systems and AI products. Additionally, the goal is to impose regulatory requirements on providers, right? Because if it's not regulated, then it will not be safe. The second goal is to capture AI systems by the product liability regime. So right now we all treat AI systems like products, even if it's software. And the idea is to give a legal basis for that. Then the idea of this new regulatory framework concerning liability is to empower individuals to effectively pursue claims. So there is a litigation issue, and there are new procedural tools which are proposed for individuals when claiming damages. And all this to get rid of the black box effect. So generally, the black box effect is a situation that we all know what's the input data in the AI. We know the result of a given action, but actually we don't know how the AI system works, because for us, for mere individuals, it's behind our reach. So we don't know how the system works, and therefore we need to get some instruments, to get some procedural instruments to effectively pursue and claim damages in court. And that's the general idea. And the proposed legal framework is, as you can see on the slide, there are three main acts on the table right now. So the first one is AI Act. Then we've got the new Product Liability Directive, and we also have AI Liability Directive. And these three new pieces of legislation, they are going to cover almost the whole landscape. Generally, there are different types of liability, which you can see on the next slide. So we are talking mainly about civil liability in terms of tort and product liability, plus regulatory requirements, and still to come criminal liability. I think it will have a separate regulation, and of course contractual liability, which stems from terms and conditions and other let's say individual contracts. So going to the first act, this is AI Act. This is the core regulation, core piece of legislation when we talk about the liability issues in terms of AI. And there are only problems with the act, starting from the definition, because there is a hot discussion how to define the AI system and what should be captured. So generally, it began with some kind of software. Right now, the proposed definition is that the AI system is a system with some elements of autonomy, which is based on machine or human provided data, which gives some effect, so which can make its own decisions. So for me, the element of autonomy is the crucial point here. So we are not only talking about simple software, but this must be some kind of a system. And thanks to ChatGPT, there is another part of discussion when we talk about the AI Act, so general purpose AI system, because previously everybody focused on high risk AI systems, like systems used for credit scoring or for CCTV cameras tracking our moves in real life. But now it appears that this very general systems which create content, they can be even more dangerous. They can lead to fake news. They can lead to misinformation. And now there is a big discussion how to regulate them. Generally, general purpose AI systems. So these are systems that are they include open source software, and they are applied to general functions such as image, speech recognition, audio, video generation, answering questions, and so on. So these are general systems normally created by big tech companies, and then they are used in individual products by smaller AI system providers. So that's the discussion about the AI Act, and the whole AI Act it refers to it imposes specific requirements, specific obligations on the AI system providers, starting from risk management systems, specific requirements on data governance. So the input data, training data must be of high quality, and it must be correct. There are other requirements regarding technical documentation. There must be human oversight, so the system must be controlled by human, and many more. And that's the whole framework which aims to provide the safety of the AI system. And here we talk about the liability on the administrative level, right? So when you breach the specific regulatory requirements, then penalties, very high penalties, can be imposed on you as a AI system provider, and that's the first level of liability. Yeah, the second level of liability is the regime of product liability. This is very important, and this is new for AI, right? So, but to understand this system, we would need to get some basic information about the old regime. So right now there is a current product liability directive, which provides rules for the liability of a producer for a damage caused by a defective product. And what product means? These are all movables, so tangible products, so intangible assets, intellectual property rights, like software, for example, they are not captured, so they are not qualified as products. So we are talking about only classic products under the current product liability directive. This is a risk-based liability, so and it relates only to the defective products, and the damage. This is a normal damage caused by death or personal injury. It covers also damage of any item. Yeah, and now we've got a new product liability directive, a proposal, which is a completely new area for users and for AI providers, because it also covers software as a product, and then directly it also captures AI systems, which is a big step forward, I think, and this will be a big instrument for users, and quite a big risk for AI system providers, because until now the software was not captured as a product, and now it is. Also, updates and upgrades of the software are captured. So for example, when you do some big update of your software, which is not qualified as a product, then when the new product liability directive comes into force, then it can be captured. Related services are will be captured by the new product liability directive. So for example, we have a client who provides robots, and the client operates in a robot as a service model. So the client provides a robot, leases a robot, and then the client provides a software running this robot, right? So the robot will be a product, and the software will be qualified as a separate product as well, which is yeah, I think a good step in a good direction. Then, of course, this new product liability directive will cover will relate to defects and damages which are defined in a very similar way, but there is a completely new type of damage, so loss of data, right? So not only damage caused by death or personal injury or damage to any item, but also loss of data, which is crucial in currently when the whole internet is data driven. So this is a new type of damage, and this is also very, very important. And there are two procedural aspects for individual customers, for individual users, final users of AI systems. So when, for example, you or me, when we will suffer damage, then we will be able to request AI system provider to show us, to disclose specific evidence showing how the system works, for example, because it's out of our reach. We are not able to do this on our own. So we will be able to request the disclosure of evidence, which is quite a big tool. And then there are specific presumptions. So there are specific presumptions when, so we will be able to presume when the product is defective. For example, when the defendant failed to disclose evidence, or when the AI product does not fulfill mandatory requirements imposed under the AI Act, and so on. So these are very, very useful procedural tools, and the liability of AI system providers will be also under the new Product Liability Directive when it's enacted. And the third piece of legislation that we are talking about is the AI Liability Directive. This is a new directive which provides two new procedural tools, so disclosure and preservation of evidence and specific presumptions. It will apply to non-contractual fault-based civil law claims for damages, and it will relate to claims for damages, so damages caused by an output of an AI system or a failure to produce the output, right? So it will refer specifically to the damage caused by AI systems, and it will apply to everyone. So every claimant will be able to use it, and against any defendant, right? So I will talk about this a little bit more when we go to the liability for cars, for autonomous cars. But generally, AI Liability Directive, it provides procedural tool, disclosure of evidence, so very similarly as in new Product Liability Directive. So claimant, so injured person, will be able to request the disclosure of specific evidence on how the AI system works, just to prove fault or some other violations. And then there are specific presumptions of causal link between the fault of the defendant and the damage output of the AI system. So it will be much easier to prove this causal link, and then therefore it will be much easier to effectively pursue claims, right? Which is very important for simple users. And so these are three new pieces of legislation. These are only proposals right now, and definitely there will be some changes, because we know that there's a lot of discussion about the definitions and about actually everything connected with the AI. And based on that, I would like to try to answer who is liable for autonomous car or for AI assisted products, because this is the main question of this presentation. So based on these new pieces of legislation, so I'm putting aside some local traffic laws, but we are focusing on the EU legislation. So who is liable? It depends, and that's the normal answer for a lawyer, because there are many different situations. So first of all, when you are talking about autonomous car, then we need to answer first and basic question, whether the car is actually autonomous. So is this assisted car? So are there only assisting tools which help the driver to drive safely, or whether there is a fully autonomous car, self-driving car, where the driver is actually only a passenger. So this is the first question, and it's a factual question which we need to answer in the first place, right? So but generally, when we are talking about the liability, then we've got two paths, two ways of claiming damages. So first of all, there is a personal liability, the classic one, and we can claim damages from the driver, right? So this is pretty classic liability regime. When the car accident is caused by driver's error, then we can pursue claim against the driver, right? and that's the normal situation. But what if car was autonomous? Then who else can be liable? So thanks to based on the AI liability directive and based on the this new procedural tools, it might be possible that we will be able to claim damages also from the AI system provider when we show that there was a fault of the AI system provider of this autonomous car. And we will be able to use these specific instruments like disclosure of evidence and presumption of causal links. So that's first way, personal liability with a little help from AI liability directive. And the second path, the second possibility is to claim damages on the basis of product liability regime. So this is a risk-based civil liability for product defects. And as mentioned before, AI systems will be qualified as products, right? So even AI systems, so tangible cars, and the same applies to AI systems being software. We'll be able to claim damages for AI system providers, for producers, but also for anyone acting in the name of the producer, but also against any other entities, any other providers of elements of the car. And that will be possible on the basis of this current draft proposal. But of course, there are many questions and many problems which can arise when claiming damages on the basis of product liability directive, because the car manufacturer he can always say that, for example, there was no required update of the software included in the car, or there was no network communication, so the car has no access to internet and therefore it was not able to drive properly, right? So or that, for example, the user manual was not observed. So there are many possibilities and questions and ways to exclude the liability. But in my opinion, these are the two ways based on the new proposed EU legislation regarding the liability for autonomous cars. And definitely it will develop in the future. And this is actually very important on both sides. So for end users, these are crucial instruments, procedures allowing them to effectively pursue claims, right? But on the other hand, when you are AI system producer or provider, then you need to think about how to adjust your product and your regulations, internal regulations, to comply with the proposed legislation. So the first thing to do is to take care of the design phase so that it complies with the requirements, with the formal requirements. Then AI system providers, they should do risk assessments, and they should answer the basic question whether they are actually AI system providers, whether the system that they provide is actually autonomous. Because nowadays everyone claims that their product is AI based, AI driven, which is very fancy. But I think in the future some of the providers will decide to name their products as simple software instead of artificial intelligence, because it will be easier. Then if this is a software, just a simple algorithm, then it will not fall under the AI Act and AI regulation. And but anyway, if we assess that our product is AI based, AI driven, then we should comply with the regulation, right? Because we are aware that the regulation is only a draft legislation and it will change, but I think general scope will stay as it is right now. So the ways are clear that the AI will be regulated, and when you design your product, then you can do it in a way that it will comply with the proposed legislation. So I think AI system providers, they have a lot to do right now, even if we are in the middle of the discussions and we don't know how the final acts will look like. But I think this is definitely a very interesting area, especially when we talk about general purpose AI systems and yeah, thank you for this.
Super. Thank you very much, Jakub. That was very interesting. I also liked in particular your comment that all sorts of companies are now stressing that their products contain AI. So hardly a day goes by where you do not get an email where some software company is sort of jumping onto this bandwagon. Let's move on. The next presentation is also very timely. It's on the human resources usage of AI systems. And just yesterday, I think it was yesterday or the day before, the Wall Street Journal had a hilarious article on on sort of job applicants using ChatGPT to word basically their application letter. And there was one HR lady who said she's constantly getting these very similarly worded applications, which are perfect, but they have all been written by the same AI system. So let me introduce you to Isabel Firneis. Isabel is a senior associate here in Vienna in the employment team. Isabel does a lot of work in the areas of employment litigation, also regarding newer forms of work. So platform work is one of the areas that Isabel is very specialized in. Isabel has worked as an associate with well-known Austrian firms, but also with a startup in Germany in the area of HR. It's always a pleasure speaking to Isabel, who has this very entrepreneurial, very startup-minded sort of attitude. And with this, I'd like to hand over to you, Isabel. The floor is again yours.
Thank you for the kind introduction and welcome to the final lecture of today's webinar. And well, based on Niklaus' introduction, you might have guessed it, I will now focus on the impact of AI use at the workplace. And the title of my lecture is If There Are Any Restrictions for Employers Using Artificial Intelligence Systems. And well, the use of AI systems at the workplace is and might increasingly become a legal minefield for employers. As we've all heard, AI will and potentially already is transforming our workplaces. The manufacturers of AI tools in a human resource context especially advertise their tools with efficiency gains, cost and time-saving effects, and the elimination of conscious and unconscious bias. And also from an employee's perspective, I mean, how nice would it be if, so to say, the boring tasks would be taken over by AI? And if, for example, personnel decisions such as who gets promoted would be taken fairly and not on the basis of likes and dislikes of superiors. So at a first glance, it's pretty easy to see the advantages of AI use at the workplace. However, especially employers should also be aware of the legal challenges that come with it. And well, so where are AI tools actually used in the workplace? We already see that AI is increasingly used in the entire employee life cycle, and this is especially the case for recruiting. For example, there are AI tools that perform active sourcing of job candidates on the basis of their social media profiles, meaning that the AI tool proactively seeks the perfect job candidate, let's say on LinkedIn, and writes them a message informing them about a matching job. Further AI tools are used for the review and pre-selection of CVs for open positions, and sometimes chatbots already take over part of the job interview. There are even AI tools that can analyze the writing styles of job candidates to analyze if the personality matches the job requirements. However, the use of AI tools at the workplace certainly not stops there. Also, during the upright employment relationship, AI systems are becoming more frequently used, I would say literally every day, for example, to monitor and evaluate the work performance of employees. And we also see AI systems that not only monitor the performance, but also independently suggest performance improvement plans, issue warning letters, or even terminate the employment relationship. So if we move to the next slide, in the future, your HR employee of the month might potentially look more like the picture on the right side than the one on the left. And while this will certainly reduce your personnel costs in the HR department, well, you might already want to think now about setting aside an extra budget for damage claims, because you as the employer are in the end liable for any labor law violations of the AI systems towards your employees. And to be very clear, the fact that your AI tool, without your knowledge or even intent, violated labor law for example, by discriminating against women, will not prevent you from being liable for the AI tool's actions. So if you think setting aside an extra budget for damage claims sounds overly dramatic, you might change your mind after hearing a few examples about where AI use at the workplace already went wrong. But before we dive into these examples, I want to shortly touch upon the legal basis for using AI at the workplace. So at the moment, many countries have no or only very limited laws that explicitly deal with the use of AI in an employment context. For example, in Austria, where I practice law, there are none, and I'm not aware that the Austrian government is even thinking about such regulations at the moment. However, in the EU, there are at least single countries like Spain or the Netherlands that already have specific AI regulations or are currently in the process of implementing those. Spain, for example, has published a national AI strategy that also includes concrete measures in context with employment law. But at least for now, I would say that most EU countries have no or only very limited laws that address the use of AI in an employment context. However, this does certainly not mean that the use of artificial intelligence at the workplace is a rights-free zone. Looking at this more from an EU context, from an EU perspective, we have certain minimum employment law standards that offer at least a certain layer of protections to employees in context with AI use. However, these regulations were certainly not specifically designed in this context. For example, based on the EU Anti-Discrimination Directive, any discrimination based on gender, racial or ethnic origin, religion or belief, disability, age, and sexual orientation is forbidden. And as we will see, algorithms, however, often unintentionally violate these ground rules. Further, especially the GDPR provides for additional protection of employees in context with the use of AI systems at the workplace. And well, first, employers cannot simply process personal data because they wish to do so, but data can only be processed where there is a legitimate ground to do so. Like, for example, there has to be a legitimate reason for processing the data, including the fulfillment of a contract, compliance with legal obligations, consent in a certain way of the employee, or legitimate interests. However, the mere consent of an employee might in many cases not be enough, since consent has to be given freely. And in the light of the imbalanced relationship between the employer and the employee, meaning that the employee is usually under pressure to agree, the employer can in most cases not rely on such a consent, meaning that it's invalid. Further, even in cases where the consent is freely given by the employee, such consent could be withdrawn at any time for the future. Another key principle of the GDPR is transparency, which requires the employer to provide individuals with mandatory information about the processing of their personal data, including the reason why it's being processed, the legal basis, who it will be shared with, and how long it will be retained. And employers will therefore need to reflect that in their privacy notices to ensure that employees subject to the AI technologies are made aware of its use and that they get this information. And further, the GDPR also provides for restrictions when it comes to the purely automated decision-making, which is also important in context with AI use at the workplace. So summarized, there are already now several EU regulations that provide at least for a certain minimum layer of protection when it comes to AI use. On a local law level, it should also be noted that especially the regulations regarding the co-determination rights of the works councils often provide an additional protection for employees in context with AI use. For example, in many countries, works council agreements are necessary before an employer can even implement or use certain AI tools. For example, if they touch upon human dignity. And in the course of negotiating such a works council agreement, the works council will certainly ask for more information, how this tool really works, what data is being processed, for which reason, and therefore they will not agree to such a works council agreement if there's any violation of labor law. However, regardless of the mentioned layers of protection, overall there's still a number of protection gaps for employees. But I must say it's also an unsatisfactory situation for employers, as they are often unable to fully assess the legal risks of an AI system in advance, as there is no uniform and clear set of rules, and then in the end, the court decides. So the current efforts at an EU level to uniform and regulate the use of artificial intelligence are therefore, from an employment law perspective, very welcome, and in my view also really necessary. And in this context, we heard it before by Jakub, especially the EU AI Act and the AI Liability Directive must be mentioned, which, however, have not yet been finally adopted. And according to the current proposal of the AI Act, AI technology used in employment, management of workers, and access to self-employment is considered as a high-risk AI system. And such high-risk systems will be subject to heavy compliance requirements before they can be put on the market or can actually be used at the workplace. So, for example, such AI systems will have to undergo broad upfront testing, ensure high quality of training data, and appropriate human oversight. And therefore, the new AI regulations, if they come into force as they are right now, will impose a load of additional obligations on both the providers of such AI systems, but also employers who are using them. So besides the mentioned AI-specific EU regulations, it should also be noted that there are other upcoming EU directives, such as the one for platform work, which concerns me quite a lot. And this one includes specific regulations in context with AI use as well. So we see that the topic of AI use is a really hot topic on an EU level, and the protection of workers' rights in context with AI is not taken lightly, at least at the EU level. It is, however, still a long way to go until the mentioned legal acts will come into effect and before employers must actually comply with them. So, well, to show you what can and actually did go wrong when using AI, I want to give you a few real-life examples so you see the problems. So first, there has been a case where an AI machine learning tool came to the conclusion that the two key factors for a successful employee are if the person is named Paul and if Paul played lacrosse in college. And while this is not only discriminating against women, it might also discriminate employees on the basis of disability or other protected criteria. And it's clear that the development of such tools is super time and cost effective. So, I mean, it's really expensive. So that's not a nice outcome if your tool in the end comes to such conclusions. Well, another big international company developed an AI tool that in the end self-learned to filter out job candidates whose CV included the word woman or women. So applicants who went to a women's college or played in a women's league were out. And while the algorithm itself was in no way designed to discriminate against women, it self-learned to do so on the basis of the providing training data. And well, while these are certainly more extreme examples, I want to give you another one that is potentially not so obvious at first. So what if the AI tool filters out job applicants on the basis of gaps in their CVs? So let's say a 1 to 2 year pause or even longer between jobs. Well, women are much more likely to have such gaps due to becoming a mother or subsequent childcare. And so while the criterion of a gap-free CV at first looks perfectly objective, it can actually lead to an indirect discrimination of women. And well, if we are talking about discriminating against women, we certainly have to talk about Frank. You might now wonder, who is Frank and why is he discriminating against women? And don't worry, I don't want to serve any cliche. Frank is not a middle-aged white man. No, you've guessed it. Frank is an AI tool that was used by a huge food delivery platform called Deliveroo in context with the shift booking of their riders, the delivery riders. So in a nutshell, and I must say it's a really complex case, and I'm only going to give you a snippet of it. So in a nutshell, the riders were scored by the AI tool, and riders with a higher score were able to book better shifts and therefore earn more money. And for the scoring, the AI tool, for example, took into account the reliability of the riders, which meant, for example, if they were able to work the shifts that they pre-booked. And in 2022, the Labor Court of Bologna in Italy found that Deliveroo's handling of the shift scheduling violated labor law and was also found to be discriminatory, as Frank, for example, did not take into account the rider's reasons for being unable to work. And especially like in the case of women, they had to fulfill their parental duties or care for a sick child and were thus unable to perform their services that they pre-booked. And Frank did not foresee any fallback mechanism, so there was nothing to prevent a bad score of women. Well, and the court therefore found Frank in violation of labor law and indirectly discriminating against women. And I want to mention that certainly a scoring system of employees' riders can be designed in a way that it's not discriminatory, but in this case, the platform was unable to provide data that showed otherwise. And there's one last example that I want to mention. In a recent default judgment in the Netherlands against Uber over alleged robo-firings of drivers. So here the algorithm, based on certain criteria, just fired people. And the court ordered Uber to reinstate drivers who were unfairly terminated by this algorithm. And the decision was mainly based on Article 22 of the GDPR, which provides, as I said before, for certain protections for individuals against purely automated decision-making. So as we see from the mentioned examples, although the use of AI at the workplace has certainly many advantages, many benefits for employers, its use also bears legal risks. So to wrap this up and to see what key takeaways are there from this lecture. First and foremost, you as the employer are liable for the actions of the AI tool, and you open yourself up for liability. And therefore, employers should review and regularly update the training data as a first step if you certainly are the developer of the AI tool. Otherwise, you need to talk with your provider and ask them what the training data is and how you can make sure that discriminations can be avoided, for example. Further, certainly you also need a good understanding of the algorithm itself, and you need to review it regularly due to its constant changes. And this brings me to my final conclusion for today's webinar. Given the skills that you will need to do all that, likely your HR employees will need additional skills. So your HR department of the future might look different than it does now, as you might need a data analyst or a person with in-depth understanding of AI in your HR department. So be prepared, and thank you for listening.
Super. Thank you very much, Isabel, for your presentation. This was the last of these 4 parts. And before we go to the Q&A session, before we ask questions to the 4 presenters, let me point out that this is the second of 3 webinars dealing with AI, dealing with artificial intelligence. The third one will be in 4 weeks' time on the 28th of April, and we will be looking at deepfakes. This is a very timely topic. You might have seen the Donald Trump and the Pope Francis deepfakes that are going around the internet. We will also be looking at data protection issues. So there are some questions that AI technologies raise in this respect. We are going to take a more detailed look at the AI Act, and we're going to also look at chatbot lawyers, so basically our competitors. Okay, so there's the 28th of April. If you have registered for this session, you will get an email with the registration details for the last session, for the 3rd session, and you will also be getting the slides as well as a link to the video of today, if you would like to review that. In the slides, you will see the contact details of all 4 speakers, and if you have any questions, please feel free to reach out to them. Now let's look at the questions. And by the way, Alexander Miklauds has put into the chat a snippet, very interesting. Just a few minutes ago, it's basically breaking news. The Italian Data Protection Authority has said it will immediately block and investigate OpenAI over allegations that its tool is processing the data of Italian users and is breaching various legal norms in Italy. So things are moving really fast as we speak. AI, an important AI application has just been it's just being started to be investigated by Italian authorities. Okay, I have a few questions here, and if you in the audience would like to ask something, please put it into the chat now. We have 6 more minutes to go. I will begin first of all with a question to Paulina. And Paulina, you pointed out in your presentation that it is necessary to have a certain artistic content, a certain level basically, if you want to sort of get copyright protection, it should be there should be a certain threshold passed. It does not have to be sort of a very very creative or very stylish or very sort of high level work, but you need a certain minimum content. And I'm asking myself now, if I as the user of an AI system like Dall-E 2 or Midjourney, if I just type in photo of Ed Sheeran, I understand that this is not a lot of effort that I've put in, and that I should not be rewarded with the copyright of the picture that is generated by Dall-E 2 or by Midjourney based on this very short prompt. So I type in photo of Ed Sheeran, that is not yet that does not yet fulfill the threshold. But I mean, you can type in a lot of additional factors, circumstances, and the prompt can get really long. Yeah, for example, I would type in a marble statue of Ed Sheeran in the style of a Roman emperor holding a laurel wreath, and then you can also include things like high quality photography, Canon, EOS, something camera, very precise, super artistic, and these prompts can get really long, like meaning spanning half a page of text. So do you see sort of that at some point your assessment may switch? So could it be that if you have this really long, well-crafted prompt, that at some point a court would maybe say, well, this is not a very short prompt, this is something really elaborate, somebody has been trying out many things, has come up with a long prompt, and this would then qualify for copyright protection, the generated image. So what is your, sorry for this long question, what is your view?
Yes, that was maybe something what I mentioned just shortly, and that maybe it was not so recognizable. So maybe in general, the question is not so much how creative your input is in the prompts, but the crucial point is that you actually don't create the output. It is generated by the program, by the machine. So it is the machine, the program, which is actually doing the creative process. You only insert the instructions, and this is considered as for now, generally rather like an idea of something, but it has not materialized yet. So you don't have the end result. And this is only done by the machine. So that's why, in general, it would not be considered as copyright protected. If, however, and this is the thing what I mentioned rather shortly as under the slide workaround, possible workaround, it is debated at least if the decision-making process of the program is so minimal that actually exactly all the creative process comes through exactly this elaborate, very detailed, very creative instructions, then maybe it would be possible to argue that exactly the AI is really simply a tool. It just executes what you said, and there is no creative factor, no guessworking anymore how it will look like in the end. So that would be something, an argumentation in this area or in this direction, because exactly you could see it then simply as a tool, like a brush, or like I mentioned, these artworks from paintings from Jackson Pollock or Nietzsche, where they also just like dripped paint or blood on a canvas, and of course they didn't know how it would look in the end. So so it was just a tool. The paint, the brush is just a tool, and so possibly maybe under such circumstances it could be considered that the AI is then also just a tool, but that would be of course a very specific example.
Perfect, thank you very much for this. My next question would be to Isabel. Isabel, you had mentioned human dignity in the employer-employee relationship in work conditions. So I read an article about a call center. Basically, it's a kind of huge facility with 1,000 people sitting there with headphones and dealing with angry customers. And the operator of this facility did not replace all of the workers with an AI tool, but actually introduced an AI tool, and it gave a nice name to this AI tool. I don't know, maybe Lucy or I don't know, something, some other name. And when the worker was basically having the conversation with the customer, so when the call center employee was speaking to the customer, the AI system was listening in, so listening in on 1,000 conversations in parallel and making helpful suggestions. For example, say this, say that, do not mention this, do not mention that. And my question to you is, would that sort of be problematic to have somebody sitting basically on your shoulder and the whole day giving you helpful or not helpful instructions what to do? Because many people working there said, I've been working here like 30 years. I know exactly how to do it. And this system is basically really pesky. So what is your view on that?
Well, yeah, that doesn't sound nice at all. And this is quite an intense level of control, as you have no second for yourself, but you are monitored like the entire time. And most likely something like that will not maybe touch, but even breach human dignity. And the introduction might not be possible without a works council agreement. And even then there might have to be some adjustments. So yeah, this is certainly problematic.
Thank you very much. I thought so, but good to hear it from an expert. So my next question would be to Jakub. Jakub, you mentioned all of these new EU acts of legislation on the horizon. I have actually two questions to you. So the first one is, I mean, are there sort of significant flaws in these acts? That is the first question. And the second one, maybe a bit more humorous, is there was mentioned in, I think, Peter's presentation, Copilot, which is a tool for programmers which writes computer code. Should we actually in the future give legislators such a kind of program to write not computer code, but laws, to write statutes, to write legislation? So Jakub, what is your view on this, on these two questions?
Every help for legislators would be very useful, I think. Just to shorten the acts, that should be the first assumption. But yeah, answering your first question, are there any flaws? Yeah, I think this is thanks to ChatGPT, it looks like general purpose AI systems are becoming main actors here. Yeah, because generally everybody focused on high risk systems in human resources, in CCTV systems in the cities and so on. They are of course very dangerous, but in my opinion they are somehow under control. Yeah, because they are under control because they are not used by everybody. And here we have this ChatGPT or Midjourney, and we have photos from photos of Donald Trump being arrested, right? And so it's we can easily imagine that that this type of content can be very, very, very dangerous. And right now, these systems, they are not qualified as high risk. And there is a concept to qualify them as high risk, definitely. And I think this is a good direction. There should be some, let's say, conditions, but definitely this is high risk in terms of deep fakes, in terms of misinformation, because I think it can create more harm to the society as such. This fact that we don't know what's the source of given information. So and the whole world is driven by information. So this becomes the biggest issue here. And I think there is a change in the attitude, right? So how to approach this whole concept of artificial intelligence. There is a switch from classic high risk systems to maybe this new but even higher risk systems. I think so. That's the flaw. I think that's the direction.
Super. Thank you very much, Jakub, that is very helpful. And then my last question, because we're already over time and we're sort of closing off shortly. My last question would be to Peter. So Peter, you mentioned in your presentation these images that contain basically a watermark by Getty. So they have been on Reddit, for example, numerous pictures generated, for example, by Dall-E 2 that clearly show the Getty watermark. So Getty obviously is not very happy about this because this is a commercial enterprise that's selling photos by professional artists for a lot of money, and they were sort of not happy that they had been ripped off. But what is, I mean, this is maybe not a question to a lawyer, but maybe because you have a lot of understanding of this space, I would be interested in your view. What is the way out for Getty if there's like this huge competitor or these competitive systems generating millions of pictures every day, and basically these companies selling photos, they look quite stale. So what is your view on that?
Well, many thanks, Nicholas. This is definitely a very tricky question. I think there's definitely legal tools to help Getty in order to navigate through these issues, but definitely these would require them to sit down with their counterparts, or at least try to engage them in a way to, as I've mentioned, the providing licensed data sets is definitely something that allows then the generative AI provider platforms to do their thing without a headache. And I think the future may be or can be, or a solution at the moment can be, if the issues around who creates, by what tools, by which prompts, by what algorithmic elements and what output, if that is something that cannot be nicely managed and it cannot be clarified in a way that's acceptable for all parties involved, the users, the copyright holders, and for the providers overall, then a fair solution is that these huge databases engage with their users in a way that's commercially acceptable, and try and work out a way that creates a fair compensation to those creators, that there's then no legal backlash or no reasonable legal backlash from those huge amounts of pool of creators, and then the created artwork also carries less legal issues with it, and it's definitely a discussion between the parties, which will be shaped by the current ongoing court decisions, as well as how the regulators will approach these issues. But definitely challenging and very exciting.
Super, thank you very much for this. Okay, that's it for today. I would like to thank the four presenters, that is Isabel, Paulina, Peter, and Jakub, for their presentations. I would also like to thank you as the audience for your patience, for staying on until the very end. And I do hope to see you on the 28th of April. As I said, you will get an email with the registration link if you have not yet registered for that event, and would be very happy to welcome you in 4 weeks' time. So thank you very much.